Good afternoon and welcome to this webinar, which is part of our series of the COVID-19 related webinars. I do appreciate you taking the time out today. I know we're all time poor, what with homeschooling and working from home and the various challenges that brings, but we are grateful for you taking the time to connect to us during this time. Here at Irwin Mitchell, we're trying to bring together all of our colleagues, our clients and our communities, and so please do let us know if there's anything we can help with, or if there's any other topics or suggestions you have at this time of crisis. So my name is Katie Byrne and I'm a Senior Associate Solicitor in our Commercial Dispute Resolution team. My colleague, Stephanie Reeves, who will be co-presenting with me today, is also a Senior Associate in the Commercial Disputes team. Today, we're going to be discussing the insurance market's response to COVID-19, to look to see whether we might be able to claim any losses from those, and also consider any claims we might have against third parties, such as professionals, as a result of the losses which will unfortunately inevitably flow from the current crisis. We will have some time for questions at the end, and thank you to all of those who've taken the time to submit questions to date. If you would like to ask a question, then there will be a Q&A function which should be on your screen, and we'll answer these at the end. You can also submit questions to us after the event via our events email address. And just to let you know, this webinar will be recorded and we will send you out a copy of the recording after the event. So the coronavirus pandemic is having a significant impact on all businesses across all industries and across the world. Businesses have been forced to close, we've sent staff home, we've had to cancel events, cancel travel plans, and unfortunately we all face an uncertain economic climate. And in these times, businesses will look to see who they can look to for those losses. The government will provide some support, and indeed we've already seen this with the furlough scheme, but it's anticipated that the loss that businesses will suffer will unfortunately far outweigh the support that's going to be available. So will the insurance industry pay out? There's been quite a lot in the press about this. Insurance could provide some vital support to businesses. I'm going to start by looking at business interruption insurance, and this is usually designed to cover financial losses following physical damage to a building. Now, it is possible it will also cover financial loss resulting from any insured event, which could also include disease. As with any policy, the devil will always be in the detail. Some insurance policies will list infectious diseases that they will specifically indemnify, and others will list those that are excluded, so that all non-listed diseases will be covered. Now, for any policy taken out prior to January 2020, it's highly unlikely that COVID-19 will be specifically listed, because its existence just simply wouldn't have been known about. So we'll have to have a look to see whether or not your policy covers a notifiable or infectious disease. One thing to bear in mind, if you have a list of included diseases, unfortunately it's unlikely COVID-19 won't appear, and therefore it's unlikely that you will be covered. But if you have a list of excluded diseases, COVID-19 won't appear, and therefore you might be covered. But let's have a look also at the severe acute respiratory syndrome, otherwise known as SARS. Following the 2003 outbreak, many insurers did list SARS as an infectious disease, and often they were excluded from policies as well. Now, the World Health Organization has confirmed that COVID-19 and SARS are genetically linked. So is it possible that if you're covered for SARS, you might also be covered for COVID-19? This is something that I think is an interesting argument that could be run. Unfortunately, my view is that insurers will look to distinguish between the two. And unless and until the court makes any form of determination on this, then we just simply won't know how that will be treated. So what about the forced closure of businesses? On the 21st of March 2020, the government brought into force the Health Protection Coronavirus Business Closure England regulations, and this required businesses across the country to close. The regulations have since been amended but essentially it requires a list of businesses and venues to remain closed. And in addition to that, workers who can work from home have been advised to work from home, and that is still the status quo. So the question which arises here is, if losses have been incurred as a result of the forced closure of a business, was it the forced closure as a result of COVID-19, i.e. as a result of the infectious or notifiable disease, or was the closure as a result of government intervention? Some policies will cover for losses as a result of a notifiable disease. Others may cover for losses associated with a forced closure. Some may cover both. And as before, unfortunately, the devil really is in the detail of the drafting of your policies. Recently, Raymond Blanc's Brasserie Bar Company was refused insurance cover after he closed 37 pubs and restaurants. And it's been widely reported that the company had cover for issues caused by a contagious disease. However, the insurer has said that its core policy wordings do not provide cover for business interruption as a result of the government's response to the pandemic. They say, therefore, that the forced closure was as a response to government intervention, and therefore they don't have to pay out. Now, I can see the argument there, but equally I can understand why people are probably jumping up and down on their seats to say, well, the government closure intervention was as a result of COVID-19. So it will be really interesting to see where that court case goes. And indeed, I understand there's a group action taking place. So hopefully we will get some sort of response to that question. What about policies that say they will only provide cover if the disease itself is not only caused a loss, but has also manifested itself on or nearby a business premises? I have seen many examples of this type of clause, and typically policies will require the disease to have manifested either on the premises or within a 25-mile radius. Now, it's of course important to remember at this stage that policies were rarely created or drafted with any form of international pandemic in mind, and therefore instead they anticipate a more localised event where this type of thing would be easier to show. So if insurers seek to run this argument that a disease has not actually manifested itself on the premises, what can we do? We suggest that businesses check to see if there's a hospital nearby where there might be COVID-19 patients within a required distance, and also to maintain a record of anyone who has been on the premises and who has displayed COVID-19 symptoms. In addition, we've got the government daily figures of COVID-19 cases, and these can be broken down by region. So these statistics could also be used to further the argument. Unfortunately, as with before, ultimately, this sort of argument will only know whether this will be successful for us when it comes before a court to determine. But I do think it will be hard for any insurer to say that when we have a worldwide pandemic where all businesses have been forced to close, that actually it didn't or shouldn't have affected that business's premises. And what about buildings insurance and loss of rent insurance? Now, I appreciate that this may not, on the face of it, be relevant to all types of business, but it is interesting to consider how the insurance market will react to buildings insurance and loss of rents claims. Indeed, most businesses are, after all, either a landlord or a tenant. So, what about rent suspension clauses? Many leases have a rent suspension clause which will state that if the premises have been damaged by an insured risk, then the rent will cease, and then the landlords in turn can claim the loss of rent from insurers. However, the premises need to be damaged or destroyed. Some leases may be more broadly drafted, and this could include making them inaccessible. So perhaps this could kick in, and a tenant could argue that a rent suspension clause should apply. However, most rent suspension provisions do require damage or destruction, and so this should mean that this kind of claim may actually fall at the first hurdle. Secondly, the damage or destruction, or indeed the prevention of access, must have been caused by an insured risk. Now, it's highly unlikely that COVID-19 will fall within this definition of insured risk, and even if the lease does provide cover for uninsured risks, typically diseases are excluded. So it's important to have a look at your leases and your rent suspension clauses in this respect. What about loss of rent more generally? Can landlords recover this as a form of business interruption insurance? Possibly. From the beginning of lockdown, landlords were faced with requests by tenants to waive or defer rent, and many landlords were happy to facilitate this because their tenants were generally struggling and they were forced to close as a result of the pandemic. The government has brought in a series of changes which have had the effect of significantly restricting a landlord's legal remedies against tenants in respect of unpaid rent. And while some of the detail of this is unclear, the key message is that landlords and tenants should work together to find a solution. And indeed, I know many landlord clients that have done that. But whether or not cover is available for landlords will depend again on the wording of their policies. I'm afraid you'll get sick of me saying that. But however, this raises an interesting question. Is there a potential cover available, and how has the loss of rent occurred? Insurers will expect landlords to have done all they possibly can to recover the rent, and this might be difficult in times when the government has actually encouraged landlords to negotiate with tenants and also restricted the landlord's abilities to enforce rent. And what implication does this have on tenants? If landlords can recover under their insurance policies, will insurers then bring claims against tenants in an attempt to recover rent at a later date? Indeed, insurers won't have the commercial relationship that a landlord and tenant have, and certainly they won't be impacted by a tenant going bust as a result of a later claim for rent. And all of these things need to be considered from a sort of commercial angle, as well as from a recovery of loss position, because a landlord will not want their tenant in a year or two's time to go bust as a result of the fact that their insurance company has sent them bust looking for that lost rent that they claimed the year before. What about public and employers' liability? Now, it remains to be seen whether people will bring claims against businesses for failing to put in adequate measures to prevent the spread of COVID-19, but this might happen. And if these claims arise, it is possible that businesses will be covered by both their public and employers' liability insurance. However, the key here really will be, can the claimants actually prove that they contracted the disease whilst in the business premises? And I think that's highly unlikely. As I mentioned previously, businesses can keep records of people who come into their premises and display COVID-19 symptoms, but I do think it'll be difficult for anyone to get over the hurdle of actually proving that it's as a result of them being on premises or of a result of a business failing to put in adequate measures that they contracted COVID-19, particularly seeing as it's such an infectious disease. Now, what about event and travel cancellation? I know lots of us have had to cancel our holiday plans, travel plans, events that we were looking forward to. And you'll be pleased to know that this is hopefully going to be an easier type of insurance to claim upon. However, it will not be without its difficulties. Travel cancellation insurance policy may, I think, provide cover for businesses and for individuals who cancelled their plans as a result of COVID-19. On 17th of March 2020, that's the date that the Foreign and Commonwealth Office advised against all non-essential travel overseas. And it's likely that policies will cover the costs of cancelled or rearranged trips, provided that the policy was bought prior to this date and provided the cancellation took place after this date. It's important to remember that most policies will only pay out on irrecoverable costs. So it's important to first of all pursue a refund, look to reschedule, look to the airline, look to the travel company, look to the tour operator for a refund or perhaps even a delay in the booking prior to going to the insurer. It's important to note as well that travel insurance policies do not usually cover a disinclination to travel. And this means that as a result, for those businesses and individuals who took the decision to cancel trips prior to the FCO advice, then it might be that they're not covered for that type of cancellation. So it's important again to check the wording of your policies. Event cancellation insurance policies may well provide cover for cancellation of a pre-planned event, A short list of specific incidents are usually excluded from cover, but generally a policy should be carefully checked, and generally if infectious diseases are covered, then businesses and individuals should look to try and recover any losses that they have incurred as a result of a cancelled event. So if you've got your insurance policy, what are you going to do? If you take one thing away from today's webinar, I'd ask that you please all go away and carefully check the wording of your insurance policies. Discuss them with your brokers, put in a precautionary notice of claim if you're unsure, discuss them with your lawyers. There is no specific framework for how a claim ought to be brought and how it ought to be made under a policy, but you must always check the wording of your particular policy. For example, some policies will themselves define the procedure of how to make a claim, including the steps that they expect businesses to take in order to try and reduce losses. For example, you may have when to notify the insurer, what information they require, and things such as that. And failure to follow that procedure can in itself result in a refusal to pay out. And it'd be awful if you did have a good claim, but as a result of failing to follow correct procedure, that claim was rejected. So it's really important to read those policies. And what do you do if your claim is declined? In my view, the insurance market will not want to set a precedent here. It won't want to be taking on the burden of all of these types of claims. Indeed, if the market did pay out on all claims, it would likely ruin the market. The insurers just do not simply have enough cash to pay out for all of the losses that businesses and individuals are unfortunately going to incur as a result of this crisis. So the Financial Conduct Authority, the FCA, it has provided guidance to all CEOs of insurance companies, and it's urged them to respond to each claim promptly and in accordance with policy wording, which is what they should be doing anyway. Notwithstanding that, I think it's highly likely that insurers will take a bullish approach, and unless absolutely clear, claims will likely be declined, at least with that when we haven't got any other form of court guidance, which we don't at this stage. So what can you do in response to this? Ultimately, for most businesses, it will not want to be the one to take the first test case through the courts. And instead, you should simply take steps to preserve your position, which is why you should make your notification and put your claim in. Earlier on this month, the FCA, that's the Financial Conduct Authority, has announced that it will be commencing a court action to get to the bottom and get some clear guidance from the court as to some of the many issues and questions which remain unanswered, particularly in response to business interruption insurance. You've also got lots of group actions that are being threatened at the moment. You've got the Bar Brasserie Blanc one that I was mentioning earlier. I understand that there's an intention for that to be brought as a claim as well. So watch this space and hold on, put your notifications in, and hopefully we will get some answers and the courts will look to deal with these issues promptly, because they are affecting many businesses. So what are your options if your claim is declined? As I mentioned, there are court proceedings. Now these are expensive, and my advice would be that we probably wait until the FCA has got through their court proceedings to see if we can take any guidance from this. But it's important to note, as I've said plenty of times in this webinar, that everybody's policy will be individually and specifically drafted. So even though the FCA will get some guidance, it will not necessarily be on the same points or wording as your policy. But you could think about alternative ways of funding litigation, and that could be of interest for you. And particularly, as I mentioned, there are some group actions that are taking place that I know of, and I know that these will likely be funded by litigation funding organisations. So if you do think about issuing court proceedings, have a look online, chat with your solicitors and see what options are out there. But certainly funding is something you should be considering. A second option for you could be to make a complaint to the Financial Ombudsman Service. Now, the upper limit of compensation for the Financial Ombudsman Service is currently £355,000, and it is available to most businesses. It's certainly cheaper and a lot quicker to get a resolution on these, Again, though, the Ombudsman Service may well be waiting for some guidance, particularly to the FCA's court case, which they're currently bringing. And finally, what about third parties? Can you look to bring a claim against your insurance broker, perhaps, who may not have put in the required policy that you require? If you find you're not covered for those losses, I suggest you certainly look to those options, and Stephanie is going to explore this in further details for us. Stephanie.
Hello, and welcome to the second part of today's webinar. As Katie said, I'm Stephanie Reeves. I'm going to be looking this afternoon at claims against professional advisors to recover COVID-19 related losses. Now, in any economic downturn, we usually see a spike in claims against professionals. When times are tough, businesses and individuals who are feeling the pinch will try and recoup any losses from wherever possible, and that includes from their professional advisors. And this was certainly demonstrated by the spike in claims against professionals, which arose from the residential housing crash in 2008. I'm going to have a look at some of the types of claims which we particularly expect to see as a result of COVID-19, as well as some of the challenges faced by those pursuing such claims and some practical tips for doing so. There we are. So the two causes of action that we tend to look at here are, they're up on your screen: breach of contract and professional negligence. Now, we tend to see these being brought together as concurrent claims in negligence and tort, and it's worth just spending a bit of time looking at the elements of both of these claims. Now, for a breach of contract claim, there are three elements which I've put up on your screen. You need to have a legally binding contractual term. That term has to have been breached, and the breach has caused or is likely to cause loss. Now, you can see quite easily how this will come into play where you have a professional to client relationship, which is based on or governed by a contract, as they all should be. Moving on to look at negligence, which is the focus of today's webinar, you'll first have to establish a duty of care. For negligence to be established, the defendant professional must owe the claimant a duty to take reasonable care not to inflict damage on him or her. And in ascertaining whether a duty of care exists, courts look at various factors, such as whether there is the reasonable foreseeability of damage, whether there exists a relationship of proximity between the claimant and the defendant, and lastly, whether it's fair, just and reasonable in all the circumstances to impose liability, which is a nice little catch-all which lawyers like. Now, examples of the types of classes of relationship where a duty of care is generally assumed are employer to employee, driver to pedestrian, lawyer to client, and doctor to patient. Now, once you've established a duty of care, as a claimant, you'll need to then move on to look at the scope and the standard of that duty of care. In a professional negligence case, the standard of care is quite simple. It's that of the reasonable skill and care expected of a reasonably competent professional of that kind. However, the question of scope in a negligence case is key and is going to be a potential challenge, particularly in relation to COVID-19 related cases, because claimants will need to ask themselves precisely what the professional had a duty to do and to define the extent of that duty. And in particular, there's a distinction made between a professional who only owes a duty to provide information and one who owes a duty to provide advice. The courts have held that where a professional has only been under a duty to provide information, and a claimant has used that information to decide on a course of action, if the professional is negligent, he will not usually be regarded as responsible for all consequences of that course of action. He's only responsible for the consequences of the information being wrong. Now, by comparison, looking at an advice case, a defendant's duty will be to advise on whether a transaction or a course of action should be taken, and therefore the defendant's duty is significantly wider. Now, you can see from that analogy that extreme market losses, such as those that we unfortunately are likely to see as a result of COVID-19, could potentially be recovered from a negligent advisor in one of these advice cases, but not in an information case. Therefore, this analysis is going to be crucial. Looking at breach, which is the third bullet point on your screen, a defendant will be in breach of duty where they fail to take reasonable care to prevent the sort of harm that is contemplated within their duty. So courts have to consider what a reasonable person in the position of the defendant professional might be expected to do, and then to look at whether the defendant has lived up to that standard. Two issues just to raise on this. Firstly is that the court will judge whether a defendant has failed to live up to a reasonable standard by taking into account what would have been expected at the time of the alleged breach, and not what would be expected today. The second issue is that while the court is looking at the behaviour of a professional, it will need to ask what a responsible body of opinion would make of that conduct. And therefore, to determine whether there's been a breach, it's very likely that a claimant is going to need expert evidence on this point. Now, finally, on this slide, causation and remoteness. In determining damages in professional negligence cases, there is a two-stage test. Firstly, causation. Did the negligence causally contribute to the loss, which as lawyers like to call the but-for test? This poses the question whether the claimant would have suffered the loss but for the defendant's wrongdoing. If he would not, then the wrongful conduct was not a cause of the loss. If the loss would have arisen even without the defendant's wrongdoing, then normally the defendant's actions will not give rise to a legal liability. So a very important distinction there. Secondly, foreseeability or remoteness. If the negligence did contribute to the loss, what is the extent of the loss for which the defendant ought to be held liable? And this is the test of remoteness. And it seems quite likely in a lot of cases where losses have been caused by, for example, extreme or unusual market volatility, such as those, unfortunately, that we're likely to see as a result of COVID-19. It's very likely that those losses will be deemed too remote to be recoverable from a professional advisor. Remoteness, in my view, is that they're therefore likely to be a significant hurdle for claimants to overcome in the world of post-pandemic professional negligence claims. Now, moving on to some of the hotspots, the particular areas where we think we are likely to see an increase in professional negligence claims arising out of COVID-19. I'll look first of all at insurance brokers to link back to what Katie was talking about. What if a business owner has been told that their business interruption or event cancellation insurance policy will not cover COVID-19 related cancellations or closures? Can they look to their insurance broker to recover their losses? Well, in the usual way, in order to succeed, a claimant would need to establish duty, breach and causation, as I was discussing earlier. Looking firstly at duty, well, generally an insurance broker owes a duty to ascertain their client's insurance needs by taking instructions and considering the information available to the broker about the client's business. Often, the broker must then advise on the scope and type of cover available to meet those needs. Therefore, the question of duty here is going to be very much fact-specific. It will depend largely on the nature of the claimant's business, firstly, and secondly, the nature of the specific instructions that the claimant gave to their insurance broker. In practice, though, in my view, it will require something akin to an instruction to the insurance broker to obtain full cover, or more specifically, cover against pandemics, in order to establish a duty of care by the broker to obtain cover for pandemics. And even then, it must be reasonably foreseeable to the broker that pandemic cover was the sort of cover that this particular client should have considered at the time. Moving on to look at breach, if the claimant can show that the broker had a duty to obtain or advised them to obtain pandemic insurance or something similar, then it should be fairly easy to establish breach if that wasn't done. However, as I said, in practice, I think the duty of care is likely to be framed in more vague terms than that, in which case breach will be harder to prove. If it can be established that the duty was to obtain full cover, then the question of breach will very much depend on the facts, because full cover is a concept which will mean different things to different people and different types of business. Finally, causation. In my view, this is going to present the biggest challenge to claims against insurance brokers, because in order to make out a claim, it will be necessary to show that, but for the breach, the claimant would have taken out insurance which covered the risk of the COVID-19 pandemic. And there are potentially two issues with this. Firstly, cost. It's very likely that any premium for a policy with pandemic cover would have been prohibitively expensive. And it's likely that in order to convince a court that a claimant would have done this, they will need to demonstrate a history of being very risk averse, which would be quite difficult. Secondly, availability. Even if a claimant can show that they would have been willing to pay for the insurance, they'll need to demonstrate that such insurance policies were in fact available in the market at that time. Because in my view, it would be very difficult to demonstrate that a broker was under a duty to obtain any sort of bespoke cover. Now, to take the Wimbledon Championships as an example, obviously the 2020 Championships have been cancelled due to COVID-19, and the All England Lawn Tennis Club, now their insurer is expected to pay out in excess of £100 million because their insurance policy specifically covered pandemics, and the premium for that insurance policy is estimated to have cost 7 figures. Now, clearly, due to the kind of all eggs in one basket nature of the Wimbledon event, the policy was seen as worth the cost, and indeed it was. Moving on next to look at legal advisors. How has the move to remote working disrupted client service? Well, again, let's start by looking at duty of care, because it's generally very easy to demonstrate the existence of a duty of care by a legal advisor to a client. Again, however, the scope of that duty will be very key, and it will depend on the specific facts, and in particular the specific terms of the instruction or retainer. Therefore, a key aspect in determining whether or not there has been a breach of duty is to consider that retainer. So for potential claimants, before you do anything, go back to your retainer, read it, read any incidental correspondence, and take the time to clearly define the scope of the retainer and therefore the scope of the legal advisor's duty of care before you do anything. Now, the types of breaches which we particularly anticipate seeing as a result of the change in solicitors' working practices to, in many cases, entirely remote working overnight. Things like IT systems failing, critical deadlines being missed. Many law firms are not truly paperless, and therefore the transaction to home working may well lead to details and deadlines being missed. And this is particularly concerning in relation to what we call hard deadlines, so limitation dates, court deadlines, they could be missed. In a similar vein, documents can go missing. We're expecting to see a high increase in the incidence of cyber fraud and data breaches. The ICO and SRA are certainly expecting a spike in the incidences. Issues caused by absence due to sickness or furlough, and supervision schemes within law firms simply failing whilst the remote working environment is ongoing. Now, again, foreseeability, I think, is going to be a significant challenge. You know, in the majority of cases, in the circumstances that I've just described, it should be relatively straightforward to demonstrate that a legal advisor's standard of care fell below their duty to exercise reasonable skill and care. However, moving on to look at causation, the claimant will need to demonstrate that the loss was caused by those breaches and that the loss was reasonably foreseeable. Now, to take an example, the drafting of force majeure clauses in existing contracts is certainly under the spotlight already. The question there will be whether it was within the scope of the drafting solicitor's duty to include or advise their client to include a pandemic as a situation which triggers termination of that contract. Now, foreseeability and remoteness will be a challenge there, because claimants must show that damage caused by not including pandemics or similar in the drafting of a force majeure clause was or should have been reasonably foreseeable to the solicitor at the time of drafting. And you can see, given the unprecedented situation that we're in, how that might be a challenge. Moving on now to financial advisors. What if your financial advisor had advised you to enter into a transaction or an investment, and you have lost money as a result of market movements caused by COVID-19? Well, the scope of the financial advisor's duty of care obviously needs to be determined first, as I've said many times so far. However, it could be said that in the financial advisor context, this is where the information versus advice distinction becomes most relevant. Now, remember, an advice case is one where it's been left to the advisor to consider what matters should be taken into account when considering whether to enter into a transaction. It's one where the advisor had a duty to consider all relevant matters in that decision, and one where it can generally be said that the advisor was responsible for guiding the whole decision-making process. And remember, in an advice case, claimants can theoretically recover from a professional all losses flowing from entering into that transaction. So you can see how, potentially in circumstances where a financial advisor has advised a client to enter into an investment or a transaction and has taken responsibility for guiding the whole of that decision-making process, you can see how extreme market losses such as those that we may well see as a result of COVID-19 could feasibly be recovered from that financial advisor. Similarly with remoteness, in the case of negligent financial or investment advice, market movements, even very extreme ones, are quite likely to be considered to be foreseeable. So it may be quite difficult for a financial advisor to distinguish between so-called normal market changes and those which have been triggered by an abnormal global pandemic. As a result, losses caused by even the most unusual market movement could very well be considered not to be too remote, and therefore could be recovered from a negligent financial advisor in an advice case. Now, moving on finally to final hotspot, auditors, and particularly how the move to remote working has disrupted client service. Now, obviously, this will result, if it hasn't already, in a lot more remote audits being carried out, which brings with it all of the challenges and risks which I addressed earlier in relation to solicitors. However, if these new working practices are not implemented carefully, you can see how things could go wrong. For example, the failure of the auditor to obtain all relevant information. Now, for example, where the judgment of management is required in valuing an asset or valuing a liability. Failure of the technology, not properly supporting audit findings, or inappropriately completing audits without undertaking a physical inspection of the company's premises, which obviously would potentially be very difficult during this period. Now, in light of the logistical changes to the way that audits may have to be carried out, the FRC is recommending that where possible, audits should be delayed or extended during this period. These logistical challenges could also lead the auditor to issue a qualified opinion, at least in relation to some specific terms. Two notes of caution on both of these. Firstly, if the current restrictions remain in place for a significant period, delaying audits simply may not be possible. Secondly, if auditors do qualify their reports, they can expect to come under pressure from the company's directors, who are concerned about the impact this may have on their business. Now, that in turn may result in more complaints or claims against the auditors. So I think it's probably worth reflecting on and summarising what this all tells us about what are likely to be the main challenges faced by anyone seeking to recover losses from a professional advisor arising out of the pandemic. Well, firstly, as I've said many times, ascertaining the scope of the duty of care owed by the professional to the client is the first hurdle. This is often not as straightforward as it seems, and the success of many claims will turn on the specific instructions which were given to the professional at the time. Whether the professional had a duty to provide advice or just information is obviously going to be key, as I've said in this webinar so far. Secondly, causation. Claimants will need to show in any negligence claim against any professional that but for the breach of duty by the professional, they would not have entered into the transaction in question. Now, this always presents a very difficult assessment to all claimants because you're using a hypothetical situation, i.e. trying to prove that something would have happened in circumstances which didn't in fact arise. It can be quite difficult. And finally, in my view, probably the biggest challenge when we're looking at COVID-19 is demonstrating foreseeability. A professional will only be liable for damage which is reasonably foreseeable. Now, in the unprecedented, largely unforeseen circumstances that we find ourselves in, is it ever going to be reasonable to hold a professional liable for losses suffered? The answer is probably yes, but only in limited circumstances. And finally, practical tips for claimants looking to bring a claim. Firstly, communication is absolutely key. The majority of complaints and claims against professionals arise from a failure to properly and effectively communicate. Engage early with the professional's complaints process, but always be mindful of any applicable limitation periods. You have an obligation as a claimant to open lines of communication on a pre-action basis anyway, under the various pre-action protocols and civil procedure rules. There may also be notification requirements in the contracts that you have with your relevant professionals, and these should be complied with. But now more than ever, it is going to be important to engage early, particularly given the current economic uncertainties being caused by COVID-19 and the increasing possibility that professional firms, and all firms indeed, may enter into an insolvency process before you've even had the chance to make your claim. Secondly, as a lawyer, I'm going to say evidence, documents. It's absolutely vital to retain an audit trail of documents demonstrating the instructions given to the professional, the information that was provided to the professional, the circumstances surrounding the alleged breach of duty, and indeed the precise particulars of the loss that has been suffered or is likely to be suffered as a result. Courts are persuaded by documents, and claims can live or die based on the strength of the physical written evidence. Engage early with any witnesses of fact on whose evidence you'll likely need to rely, and capture their evidence as soon as possible because, as we all know, memories fade. And the same goes for any expert witnesses. Engage with them early, get their evidence early. Thirdly, remember that there are always alternatives to legal proceedings. For example, the Financial Ombudsman Service Katie mentioned, the Legal Ombudsman. Always pursue the professional's complaints procedure before resorting to legal proceedings or any ombudsman proceedings. Also, remember alternative dispute resolution, things such as mediation, arbitration, expert determination. They are all available to be done very efficiently remotely. So they do remain an option and they should certainly be considered early. And finally, I would be remiss if I didn't advise any potential claimants to take legal advice. There are some very specific rules around how professional negligence claims should be conducted and particular timescales within which claims must be brought. And the failure to comply with these can, at best, lead to cost penalties being imposed ultimately by the court, or at worst, they could deprive a claimant of the ability to pursue a claim at all. So that ends my very brief overview of professional negligence claims. I'm going to hand back to Katie to, I think, look at some of your questions. Katie.
Thank you, Stephanie. So if you've got any questions, please do put them in our live Q&A box, which should be on your screen, and we'll do our best to answer those. We've had a couple that have already come in, so I'll just go through those now. The first question we've had is, I spoke to my insurers about claiming on my business interruption policy, and they said COVID-19 is not covered. But the issue to me seems to be that the government enforced a lockdown as a cause for the claim arising. I'd welcome thoughts. Well, thank you for that question. I think we probably addressed this, but ultimately you are correct, absolutely correct, in identifying that insurers may well and are likely to distinguish between forced government closure and also the closure as a result of COVID-19. Ultimately, unfortunately, whether or not they're correct in making this distinction will be something that the court will determine. And I'm hopeful that certainly the Raymond Blanc group action, which I referred to in my section of the talk, and or the FCA's court proceedings will answer this question, because I think this is something that's coming up a lot. You know, are the losses caused by the government's intervention or by COVID-19? Obviously, to you and I, perhaps there's not necessarily so much of a distinction, but insurers are making that distinction. So it's a really good question, and I think unfortunately it's going to be a question of watch this space. Let's see what the court and the FCA say about it. So thank you for that. Another question we've had, which Stephanie, I think is one for you, is I have money saved in an investment ISA. What are my rights if I lose my savings? So Stephanie, perhaps you could pick that one up. Yeah, I'm happy to take this one, Katie. Now I assume this question is being asked in relation to a claim against an advisor to recover losses, potentially a financial advisor, in which case, as I've said, you'd need to look quite carefully at what the advisor was instructed to do, and look at the scope of that duty. Were they instructed just to give you some information and you then went off and decided to invest in the investment ISA, or were they responsible for guiding the whole decision-making process? In which case you may well have a claim against that advisor, particularly or really only if you weren't advised
of the risk that you could lose money as the value of the investment could fall. Otherwise, if this isn't about a professional advisor, obviously you need to look at what the ISA provider told you, I guess, about the risks at the time of the investment. Look at the specific terms and conditions of the ISA, because I think it's very likely that it would have been made clear that the value of your investment could go down as well as that.
Thank you, Stephanie. Another question we've had in is about cyber attacks, which Stephanie referred to in her talk. The question is, what about cyber attacks which have taken place during this period? Will insurers pay out? Absolutely, there does appear, very sadly, as Stephanie was saying as well, that there has been an increase in cyber attacks during this period. Again, if businesses have their appropriate policies in place, and if they have suffered losses, they should absolutely be putting in a notification of these attacks and absolutely be putting in a claim at this stage. Whether or not the insurance will pay out will ultimately depend on the wording of your policies. But presuming that the business has done absolutely everything it can, has in place the required security which is required by the insurance policy, and there are no exclusions in the policy which relate to pandemics or infectious diseases being any cause, then I would have thought there should be certainly a very good argument that these types of attacks should be covered by any decent cyber attack policy. So again, unfortunately, it's one of those ones where it's check your wording of your policy, absolutely get your claim in. But yeah, a really good point raised. So thank you. We've had another question here, which I think actually is our last one, unless there's any more to come up, is, are we likely to see an increase in claims against surveyors for negligence surveys carried out over this period? So again, Stephanie, would you mind taking that one?
Yeah, no, happy to take that. So potentially, I think yes. I mean, at the moment, I would imagine not many surveys, if at all, are happening, not least because the government froze the property market back in March. Some of those restrictions are starting to ease, so I expect surveyors potentially could see a bit of an influx of new surveys. But I expect that social distancing will have increased the prevalence of things like remote valuations, which will have increased the risk that things have simply been missed, such as defects, and that properties have therefore been incorrectly valued over this period. And I think therefore we're probably likely to see an increase in the use of assumptions and caveats in valuation reports. So that always opens up scope for claims against valuers. And then looking probably slightly more long term at the potential market impact of COVID-19 and the chance that we could see a fall in property prices more generally. Usually this, as we saw in 2008, this will increase overvaluation claims against surveyors, particularly if market conditions mean that we see an increase in the prevalence of things like mortgage defaults and repossessions by lenders. We tend to then see the resulting claims against surveyors increasing in prevalence as a result. And that's slightly further down the line, but I can certainly foresee that coming up on the horizon.
Thank you, Stephanie. So just see, we've got a couple of questions here, so I'll just read them out. So the first one, just made a couple of minutes ago, says, Hiscox, our insurers have declined our claim, but asked whether we are within a mile radius of a hospital. We are certainly 2 miles to the main COVID hospital. How do you think they are distinguish this claim via this question? Difficult to say in particular of a particular policy wording, unfortunately, but I suspect they are looking at the radius being an issue. I don't know whether the policy that you're referring to that you've got with insurers specifically requests that you have to have had the disease either on your premises or within a mile. I know there are some policies that say that. The ones I've seen have been slightly wider and have said 25 miles. But it may well be that that is what they're then going to rely on to say that the losses can only be covered if the disease has either manifested itself on your premises or within that specific radius, but it really would depend on the wording of the policy. But I think with anything, with any of these sort of pre or post-claim discussions, you just need to be full and frank disclosure to your insurers and answer their questions. Absolutely check the wording first, have a chat with your brokers if you're concerned, but you do need to be responding to those sort of questions. So I hope that's helped that one. A second question here. We have a legal expenses insurance policy, and under our policy in which a claim has been rejected, should we check first with insurers before taking any further steps? Absolutely. Sorry, let's just check I've read that question correctly. You have a legal expenses insurance under policy. Sorry, so you've got the expenses insurance for the policy and your claim's been rejected. Absolutely. If you've got legal expenses insurance in any insurance policy, and it may well be, people often have it in their personal policies, their car, their home, then it is a very good way of funding. It can be a very good way of funding any proposed litigation or any issues you've got. I would absolutely advise that you get in touch with your legal expenses insurance covers underwriters and speak to them to see whether or not you're covered for this type of dispute, and if you are, whether or not they will take it up. You do often find examples where insurers pay out for claims against insurers, which I know is a bit of a bizarre one, but that can happen. So absolutely you should discuss it with your legal expenses insurers or any other insurers you have by way of legal expenses on any other policies you've got. So that's a good point. Thank you for raising that one. So just checking, I don't think there's any more. No more questions. If you do think of any questions after the event, please do email us, either at Stephanie or my email addresses, which were at the beginning of this presentation, or at the email address which appears now on your screen, which is events@owenmitchell.com. So all that's left for me to do is to thank you very much for joining us today. I know it's a lovely hot day outside, and I'm sure you could want to be out there enjoying it. But seriously, if there is anything else we can assist with, then do contact Stephanie or I, and we will do our best to help. And as you may know, these webinars are going out on various topics on a weekly basis. So please look at our website. I think that's just popped up on your screen, and we have a coronavirus hub, which will cover all things legal and financial, which relate to the outbreak, and you should hopefully be able to find some answers there. But if you do have any other suggestions for topics of discussion or further webinars, then we'd love to hear from you. So please do let us know if you've got any questions or comments. And finally, please let us know your feedback. We'd really appreciate it. There's a link which has now appeared on your events page, and there's a link there to the feedback survey. So please do take the time, if you've got it, to complete that, and then we can take that forward from you. So all that's left to do is to say thank you very much for joining us this afternoon. Go ahead and enjoy the sunshine, and goodbye.
Thank you.